Hello, everyone, and welcome to this episode of Pod Save Chocolate. My name is Clay Gordon. I'm your host, and today I have a real special guest for you, Terry Collingsworth, who's the Executive Director of International Rights Advocates. There was a recent decision in a DC court that is part of the ongoing saga of trying to hold Big Chocolate accountable for their inability to address the concerns that people have about illegal labor in their supply chain in Western Africa. Before I bring Terry on, I'd like to point out that this episode of Pod Save Chocolate, like every episode of Pod Save Chocolate, is sponsored by the members of the Chocolate Life. If you're not a member of the Chocolate Life, you can go over there right now, click on the join button. There is always a free membership. Right. But if you do have the financial resources to support the work that I do, there are monthly and annual memberships starting at little as $5 a month. I'd also like to remind everybody that you can go into the comments. This is the live stream, YouTube or LinkedIn or Facebook or anywhere else, and you can let me know where in the world you're connected from, and you can also ask a question of Terry and me live. And this is the post for today's episode, and this is our guest, Terry Collingsworth. Terry, it's glad to have you back again. It's been a while.
Yes, and I'm happy to say we've been getting some work done, but it's great to be here, Clay, and I look forward to just sharing with your audience some of our developments.
Yeah, no, I think this is really important. In addition to just the basic issue of human rights in the cocoa supply chain in West Africa and other parts of the world, for the last couple of years, the cocoa supply chain has been pressed with this unprecedented price increase. But now we've seen the prices crater again. And so we've seen a place where in some places in the world, there might be enough money in the system to deal with some of these systemic issues that we've been facing, having to do with illegal labor. But now all of a sudden, the price is way back down again, and the prices that farmers have been getting in Cote d'Ivoire and Ghana for the last little while, they're going to go down. It's just a real mess. It's just a real mess, right? But what I want to do is I want to go back to the beginning, if we can, for everybody who might not be aware of just how long, right, this has been going on and how long you've been involved. And I think the place to start with this is something called the Harkin Engel Protocol. So can you give us a quick overview of what Harkin Engel is about?
Absolutely. Well, prior to Harkin Engel Protocol being signed, which was in September of 2001, my prior organization, International Labor Rights Forum, went to Cote d'Ivoire and got a lot of very graphic photos of child slavery. It was very difficult to get into Cote d'Ivoire prior to the late 90s because of a civil conflict. But in the late 90s, that ended. So we got these incredible photos. Robin Romano, who unfortunately has since died, took these photos. Some of them are even on our website. But we went to Congress with this and said, look, this is horrible what's going on there. And quickly, the House of Representatives, in a bipartisan fashion, passed a bill to ban the importation of cocoa unless a particular company could show that their cocoa wasn't made with child labor. We caught the industry by surprise. It was a very, you could say, expected response from human beings. They saw these pictures and they said, we got to act. Well, then it went over to the Senate, and then the cocoa lobby went to work. They hired Bob Dole and George Mitchell as their lobbyists, and they converted this law into a voluntary protocol. So the industry said, don't worry, we're going to sign this. We promise we're going to behave. We're going to end our use of child labor by 2005, forced and child labor. So 2005 rolls around and they gave themselves a unilateral extension of time till 2010. Then they gave themselves till 2020. Then they gave themselves till 2025. And now several of the companies have upped it to 2030. In the interim, child labor has gotten worse. The U.S. Department of Labor in 2020 cited a study that they funded by the University of New Orleans, or the Tulane University in New Orleans, and found that 1.56 million children were harvesting cocoa in Cote d'Ivoire and Ghana. So the protocol was a bust.
So can I jump in here, because there's some nuance here. So we have illegal child labor, what the ILO, the International Labor Organization, calls the worst forms of child labor. And then we have this sort of notion of what modern slavery is. And so can you sort of help us deconstruct what the differences in those things might be?
Well, it is, when people start talking about modern slavery, I don't see any difference from good old fashioned slavery, which is when people are working against their will for basically nothing. And so I will be fair, though. I try to be fair and objective. There are gradations in cocoa harvesting. There are pure slaves. They are trafficked typically from Mali and Burkina Faso into Cote d'Ivoire mostly. There's very little of it in Ghana. And they are true slaves. I mean, they're bought by farmers and they work, they don't get paid. And typically they work for several years and then get turned into adolescents because they usually take them when they're like 11 years old. Then at some point, the kid says, I don't care if I die, I'm going to walk away and hope that I get somewhere. So there's that. That's the worst. Then worst forms of child labor are a category that the ILO defined after years of debate. But it essentially says, some kids can do light work and, help on the family farm and all of that. But you're not allowed to have a kid work full time, not go to school, use dangerous equipment, apply pesticides and herbicides and things of that sort. And virtually all of the labor in cocoa harvesting fits that description. The kids are using machetes to bring down the pods. They're slashing open the pods and they're applying pesticides and herbicides. So the worst forms of child labor are absolutely endemic in cocoa. Now, modern slavery, I think it's just someone's idea of saying it's still here, but I don't know that there's a distinction in terms of a definition of what's modern versus old-fashioned slavery. And I will say that, people, almost everyone of my age at least, can hearken back and say, well, I used to do some work on the family farm. Sure you did, but you went to school, your parents weren't making you apply dangerous chemicals without protection, and you probably weren't using hazardous and very dangerous equipment. So you're still allowed to do that if you're a kid. You're never allowed to do hazardous work if you're a kid.
Gotcha. I sort of wonder to what extent, there's an apologetic that's often used to sort of differentiate slavery between indentured servitude, right? That somehow the child is there and maybe they're learning the trade of becoming a cocoa farmer while they're doing this. I don't know the answer to that question, but it seems to be very much an apologetic. And I don't understand why anybody wants to be an apologist for this kind of behavior. I just don't get it. I often will say to myself, would you agree to work under these same circumstances? If the answer is no, then I think there's something, we have this innate understanding that there's something wrong with it.
Before we get to the better question, Clay, just real quick, a better question is, would you let your own child work under these conditions? And so the apologists tend to coincidentally be people who are in the industry, and they're trying again to revive the notion that this is just simple, kids working with their dads, and it's not.
Right, because as you pointed out, especially in Cote d'Ivoire, many of the children are not family members because these people wouldn't do that to their family members. They do it to other people. Before we jump out, I want to do a quick shout out to Andy LeBlanc, who's connecting from the Adirondacks in my old home state of New York. I don't know how upstate the Adirondacks are actually, Andy, will you know? But you formerly lived for 2 years in Ghana. And so, Andy, while you were in Ghana, did you have a chance to go out and take a look at cacao farms when you were there? You may not have seen much of anything. In my experience, those trips tend to be guided. And so you'll see what it is that the tour operators want you to see rather than just running out on your own. But Terry, let's also point out, you and I both have a connection with Robin Romano. So you, Roberto Romano. I met Robin shortly after the introduction of his movie, The Dark Side of Chocolate, which he did with Mickey Mastrati, right? But I didn't know that he was with you on that first journey. back, which was many, many years earlier. I mean, he was a great guy, very passionate, just a great director of photography, really committed to the idea. And he's the one who sold me on the injustice of what was going on. I met him in New York City at one of the previews very early on for The Dark Side of Chocolate, and transformative very early on in helping me understand what was going on. All right, so after Hark and Engel in 2001, they give themselves a free pass for 2005 and then 2010. So you come back as international rights advocates and you file a lawsuit against a group of quote unquote big chocolate company. I think the first lawsuit was using a legal principle around what's called the Alien Torts Act, which might be what, Revolutionary era? I mean, 1780s, 90s, thereabouts. So tell me about what that was, and ultimately how far you took it, right, and what the result was.
Sure, I have to add that. So at the time of the Harkin Engel Protocol, Senator Tom Harkin, who is the namesake, was on the board of directors of my organization, and he believed in it. He thought, the companies were going to keep their word. So I was ready to sue them when Robin got back with these photos, and we had some people that we had interviewed who were former child slaves, et cetera. And Senator Harkin at the time in 2001 said, no, come on, let's give them a chance. Let's give them a fair chance to actually do what they said they're going to do. So when they got their extension of time and had done nothing really up till that point in 2005, we went back to Cote d'Ivoire and met some kids who had been trafficked from Mali and signed them up as clients. And I came back and I filed the first case against Nestle and Cargill under the Alien Tort Statute, which, you are correct, was passed in 1789 by the very first Continental Congress. And it has like 20 words. It basically says an alien can sue in tort, so for a personal injury, for a violation of the law of nations. There is a law of nations. There's an agreed set of laws that all nations, or virtually all, agree are crimes against humanity, if you will. And among them are slavery and forced labor. So we were squarely within the realm of a law of nations violation. So we sued Cargill and Nestle. That case was really important for not only alerting the public of what was going on, because so few people realized it, but also of beginning the journey of trying to hold these large corporations accountable for what are undisputed human rights violations. These companies don't say there's no child labor. They're basically saying, well, there is, we're trying to control it. We're getting our arms around it. We have this new program, it might work. They've never said no.
And they agreed to it when they became signatories to Hark and Engel, right?
Exactly.
They basically said, yeah, we know this is a problem, right? And so structurally, right, what were the impediments to courts agreeing with you? Now, this went all the way up to the Supreme Court, as I recall, right? And
Yes.
The case that Neil Katyal argued?
That's right. Good old Neil. He used to claim to be a liberal guy, but he represented Cargill and Nestle and defended slavery in the Supreme Court by saying corporations can engage in slavery because they're not covered by international law. And at the oral argument, one of the most conservative justices ever, Justice Samuel Alito, just ate him alive over that and said, you mean if there's 8 guys and they are enslaving people, they can be liable. But if they're smart enough and form their own corporation, they're suddenly immune from the same slavery. So of course not. But to not lose track of the challenge of bringing the case initially, and I think we're getting close to solving that challenge, is that these companies, they all claim on their websites, oh, we're transparent. We're shooting for sustainability and transparency, these buzzwords they throw around. Well, they're not transparent at all. And so one of the difficulties was we find kids literally, we just drive around in Cote d'Ivoire. We stop at cocoa plantations and we find kids working. In most cases, they have no idea who they're working for. They know the farmer, but they don't know what contracts that farmer has, what Middle brokers are buying that cocoa and then selling it to one of the big chocolate companies. So that's the biggest impediment that we've faced, is really tracing the untraceable cocoa that they all claim is traceable, to hold them accountable. But with the particular case under the Alien Tort Statute, the impediment became something really different, that the industry itself organized, along with the U.S. Chamber of Commerce and every big pro-business group, and filed briefs with the Supreme Court basically saying, you can't do this. You can't allow them to sue us for what we're doing in our supply chains. That's unthinkable. It'll put us out of business. It'll destroy capitalism. I mean, they went on these rants that were almost amusing, except for the fact that you knew they were going to land with some of those justices, and they did. Mm-hmm. So the Supreme Court began putting up hurdles to cases under the Alien Tort Statute. And the very first one was in a case involving Royal Dutch Shell, not cocoa. But in Kiobo versus Royal Dutch Shell, the Supreme Court invented a test for extraterritorial jurisdiction. So you can only sue for things that happen outside of the country under the Alien Tort Statute if you can show that those claims touch and concern, that's a quote, touch and concern the territory of the United States. Now, this is completely invented. The Alien Tort Statute was meant to apply internationally, and that's why we had it in the first place. But these conservative Supreme Court justices, particularly the Alitos and the Thomases, and at the time, Anton Scalia.
So if I can really quickly, this is the same group of justices who recognize that corporations are persons. Mm-hmm. Right. So they're talking at cross purposes, right? At the same time they're doing this.
Yes, and that was really quite a surprise. I thought they'd be happy to give corporations immunity, but that was a bridge too far. But they also knew they weren't going to get sued anyways, because they were going to invent this extraterritorial test that no one could ever meet. And these originalists, as they call themselves, they claim that they just read the text, that these liberal justices, they're putting, their liberal values on what they'd like to accomplish instead of what the text says. But these textualists invented this touch and concern standard and added way more words than the entire statute to make sure that corporations would be immunized based on this test. And they made it worse in another case. And then when it came to my case, Doe v. Nestle, they made it almost impossible. At the end, when we read the decision, we sadly and cynically joked among ourselves that the only way you could hold Nestle and Cargill liable under the Alien Tort Statute is if they kidnapped kids from New Jersey and took them to Cote d'Ivoire and enslaved them. That's pretty much where the statute sits right now. So we hardly use it.
So this was all about what we might think about as jurisdiction. Yes. Do we have jurisdiction? So, is the United States in any way affronted or involved or harmed, right, by the action? And the answer is no, unless we can prove that there's a U.S. citizen, right? And let's forget what the current administration's policy is on exporting people to foreign countries for one might do. Listen, this would be interesting, taking people down to CCOT and saying, well, it's now American citizens who've been transported to foreign countries for slave, let's file a claim. That would be fairly ironic. I think. Not that it's way beyond the scope of what's going on. But I do want to get to we do have a question from Gordy Cummins, who's watching on YouTube, and I do want to remind you, if anybody who is watching has a question for Terry, go into the live chat on YouTube, or the comments are LinkedIn and Facebook. Put them in there, and I'll get the question up on the screen, and I'll ask it of Terry. And so the question here from Gordy is are Nestle and Cargill still using slaves? And what other big cocoa are guilty? Now, Terry, before you answer that, what I want to do is I want to parse around the word still using, right? Because it is this arm's distance relationship that big chocolate, and which includes the big cocoa providers. It is this we don't know what's going on in these countries. We are not buying directly, so we don't have any risk exposure to what's going on. So let's answer that question, Nestle and Cargill, around this notion, parsing around what using means. And then let's answer the question colloquially, right?
Yes.
Does that make sense?
Yes, of course. Well, first, just generally speaking, all of these companies, all of the big cocoa companies are in together an organization called the World Cocoa Foundation that is headquartered in the US, but its biggest office is in Cote d'Ivoire, in Abidjan. They all together are working on rolling out programs. They collude on what they're going to say next about the Harkin-Engel protocol, and they join communications to announce the next steps of the Harkin-Engel protocol. So I see no difference between any of the companies in terms of what's happening on the ground and their approach to it. And that includes everybody. It's Nestle, Mars, Cargill, Hershey, Barry Callebaut, Cargill, Lindt. I could go on. I don't think there are any exceptions, I would say.
Well, but I also want to say that there are big cocoa companies whose names many people may not be familiar with. So
Cargill and
a company called Olam, right, which is now OFI, Olam Food Ingredients, OFI, Soukden, Touton, right? You've got Ecom. You've got a lot of companies that you've never heard of. They're supplying cocoa beans to big processors, right? Cargill is one of them. Callebaut is another. I mean, and many of these companies have what are called licensed buying agents in the countries,
right?
And so that is part of this arm's distance relationships that the big chocolate can come. But here's another question. So just to set history, the World Cocoa Foundation was founded after the Harkin-Engel Protocol was ratified. Am I right there?
Yes, it was formed to comply with, according to them, with the Harkin-Engel Protocol. But the general point I wanted to make is that these companies are all trying to have it both ways. If you go on their websites, they're going to have some kind of claim that they don't use child labor. Don't worry, we fixed it. We're doing this. We're doing this. And they're all saying we have this child labor monitoring rehabilitation system, CLMRS, that is effectively going to end child labor. But in court, they say, that's not us. That's preposterous. We're just buying cocoa from these farmers, and there's 3 levels of middlemen, and that's not our responsibility. So they've been consistently trying to have it both ways. Mm-hmm. And that is, to me, that indicates bad faith, right? You're not really owning up to what is actually you're claiming. You're trying to have it both ways. And every single one of these companies have a policy. It's either in their code of conduct or it's on their website that they have zero tolerance for child labor in all aspects of their supply chain. They have to own that. They say that. They're telling you, the consumer, that, and we're going to get to how we're using that now in our consumer cases, but they all claim to do that. And I was just in Ghana in October, so that's several months ago, but we found kids working on cocoa plantations all day long. Nothing has changed as far as I could tell. So yes, every one of these companies is still benefiting from child slavery. They are still buying cocoa that is harvested by child slaves. And then it's a legal question of whether they are responsible for that use of child slavery.
So I think one of the questions that might have come up during the next lawsuit we'll talk about is the TVPRA lawsuit, is knowingly profiting.
Yes.
Right. But let's finish up with Gordy's question here, which I think is really, really important. You indicated that most of the illegal child labor that's going on in West Africa is happening, or a greater part of it is happening in the Ivory Coast as opposed to Ghana. So it's much more widespread today still in Cote d'Ivoire than it is in Ghana, correct?
Well, I didn't say what I meant to say was that the trafficked child labor that's coming in from Mali and Burkina Faso, it's pretty common in Cote d'Ivoire to find kids that were trafficked. It's rare to find them in Ghana, and I really don't know why. I've asked a number of my colleagues there that have experience working in the industry, and no one can really explain that to me, but I've never met, I will say, in Ghana, a kid who was trafficked from Mali or Burkina Faso, whereas in Cote d'Ivoire, I'd say about half of the kids that I've interviewed were trafficked.
So in Ghana, the children who are engaged in illegal labor and might be technically enslaved are in fact Ghanaian children.
Yes, that's correct. Yes.
Wow. All right. Something to keep in my brain. I asked the question because I misunderstood what it was you were saying, and I wanted to make sure that I got it straight. So, Gordy, I'm hoping that what we did is that Terry answered your question. So, I believe it is the case Terry, that any one of the big chocolate makers that's sourcing cocoa beans in West Africa, and more specifically Cote d'Ivoire and Ghana, right, are knowingly profiting from illegal child labor. Now, these companies are also purchasing beans in other parts of the world, Indonesia, Malaysia, many places in Latin America. And the prevalence of illegal labor in those places is much, much less, and in some cases is vanishingly small to the point of being absolutely zero, right? That the primary challenges that we're facing are in West Africa. And if I can go on a quick rant before we go to the TVPRA, Terry, what I want to say is this is one of the reasons why I resist using colonial language. So we don't live in the global north. We don't live in a developing nation. Or developed nation. We don't live in a first world country. And these are problems that happen in third world countries and developing nations and the global south. That language is inherently racist, right, and colonial, right? And one of the quick steps we can engage in is to try to adopt new language that doesn't say that somehow we are privileged, and so in our position of privilege, we're given a pass to do these things. I don't think Terry, do you think that language is a part of the challenge that we face, or is it just a lack of empathy and humanity?
Oh, I think language it's like a cover or an excuse for a lack of empathy. That when you do characterize these countries as developing or third world, then it allows some people who really aren't going to scratch the surface to basically excuse it by saying, "Oh yeah, they're poor countries. They probably welcome any job they can get, even if it's a horrible job, because they're going to starve, because that's what happens in developing countries," without at all examining the cause and the continuation of these conditions and really what the solutions are that would help these people get out. Those solutions are embedded in the people that are benefiting from and profiting from this horrific practice.
Gotcha. And I do want to point out that if you go over to the post on the Chocolate Life, there is a link to International Rights Advocates, the page, and there is a link to the current lawsuit that's going on, complaints. You've got the older Cargill Nestle. I mean, there's a history of the legal frameworks and the legal actions that we're talking about here. So afterwards you can go and you can look these things up yourself. So I just wanted to point out that Terry, as we're here. So
and we should mention that the whole story about that first case, Doe versus Nestle and Cargill, was captured on a film that the same guy, Mickey Mastrati, made called The Chocolate War. And there's a link to the trailer on our website. And then the film is available on Prime and all the other streaming services, I believe.
Right. And in case anybody is interested, I did an episode of a Pod Save Chocolate with Mickey, or the Chocolate Life Live at the time, about the chocolate war. And so there's some history there. And I believe the links to watch it are also in the episode. But, Terry, you and I have also talked about the case against Mars. And, there's a history of the conversations that we've had about this topic over the last half dozen years or so that we've been chatting. So everybody, those links are sitting over on the Chocolate Life, so you can go and do that. So you've got this lawsuit, which is associated with the Alien Tort Statute from the late 1780s. And then there's another lawsuit that was filed. And I believe this lawsuit was filed before there was a Supreme Court decision in the Alien Torts lawsuit. But it used something called the Trafficking Victims Protection Reauthorization Act, the TVPRA. So explain to us, if you will, who the plaintiffs are and what the legal theory is behind the TVPRA that's different from the Alien Tort Statute.
Yes, thank you. Yeah, the TVPRA is a more recent law. It was probably first passed in 2000, and then it has been amended a number of times to tighten it up. It was originally passed really to target sex trafficking and particularly child sex trafficking, and that drew a lot of Republican support for it in the Congress. But the language, thankfully, is not limited to that. Essentially, the fifth section 1595, 28 USC 1595 has the operative language that a person can sue anyone, a company or a person, that is the beneficiary of a venture that knowingly benefits from forced labor or trafficked labor. And so the operative elements then become you have to show knowingly benefited, which the statute defines as knew or should have known. So it's more of a negligence standard. And then the toughest hurdle for us has been they have to be in a venture. Now, this first case that we brought was on behalf of 8 Malians who were trafficked as children to go work in cocoa plantations in Cote d'Ivoire. And then they escaped, and I met them when they were back in Mali, and they became the plaintiffs. They did not know which major companies were purchasing the cocoa on the plantations they were working on. So we tried to do a statistical causation analysis where we said, all right, we know that and we sued 8 companies total. We sued Olam, Nestle, Mars, Cargill, Barry Callebaut, Hershey, and maybe 7. I think that was the list. And our argument was those companies control at least 85% of the cocoa being purchased from Cote d'Ivoire. So it's more probable than not that our plaintiffs were working on one of those plantations that was owned by one of the 8 companies that we sued. And they are all jointly and severally liable because they're working together in the World Cocoa Foundation. Now, that is a very common, solid legal theory. It's used in mass torts all the time. Like if you have 2 chemicals that are poisoning a population, both companies can be liable because it's more probable than not that one of them was. But
so if I can,
Yeah.
just because people may be wondering, I mean, often if we're watching a courtroom drama on television, right, we have 2 standards, right? One of which we might use, for example, to get a search warrant, which is probable cause, right? So it is probably likely that there is a direct causal link between it. And that's easier to prove than what we think of as beyond a reasonable doubt. So we have 2 different standards here.
3, actually.
Okay,
So
and the third one is?
Preponderance of the evidence. So probable
Gotcha.
cause gets you the indictment, but in a civil case, and that's what this is, you only have to show the preponderance of the evidence, which courts define as 50% plus 1, just a slightly higher standard versus beyond a reasonable doubt, which is for criminal convictions. So when we're using the TVPRA, which is also a criminal statute, when we're using it civilly, we only have to show preponderance of the evidence.
So I have another question here, because you talked about these big companies owning the plantations, and very rarely, Barry Callebaut, I would say, doesn't own a farm in Cote d'Ivoire, right? And so they're always working through intermediaries and cooperatives and things like that, though there's no direct ownership. Is that ownership a requirement for the TVPRA?
No, that was an error on my part. I was speaking just casually. I'm sorry. No. It's not that we don't have to show they owned it. We just have to show that they were in some kind of relationship with that plantation while knowing that child labor or trafficked labor was involved in the production of cocoa. So we just have to show that they
didn't they already cop to it by signing Harkin Engel? Didn't they already cop to it?
Well, they didn't. Yes, in the big picture sense, but what they did in court is argue that we can't show which of them or any of them actually were taking the cocoa from this particular plantation where this particular child that is a plaintiff worked.
Gotcha.
So they were requiring us, despite the fact that they don't have transparent supply chains and they won't give us that information about which plantations they're sourcing from, they argued to the court that means they can't be liable. And unfortunately, the first round of the Court of Appeals decision agreed with them and said, no, we need more than just a statistical argument. I think they're wrong, but they gave us another chance. They said, okay, this isn't going to work with us, so go back and fix this so that you're more tightly arguing how you can hold each of these companies accountable by showing that they were in a venture, had some relationship with the particular plantations where the kids worked. So we're actually working on that right now. We're going to refile this thing very soon to try again to come up with a legal theory that allows us to hold them liable, even though they're withholding specific information. But so I want to stress. Go ahead.
I'm sorry. You want to discuss what?
No, just that this is still an excellent tool. Like in Ghana, where we have a really good whistleblower now, we are able to say this plantation is sourcing for X company. We can do that. And we're working on getting that same level of information in Cote d'Ivoire. And that's going to, crack the code here for us. And we're going to be able to use this statute regularly and easily.
Okay. Before we go to the current lawsuit, the one that was just had a decision in the last couple of weeks, Gordy comes back with another question, which is, do the families of these children have employment that will feed the family? So
absolutely. No, absolutely not. That's the basic reason why this child labor exists on such a pervasive level in Cote d'Ivoire and Ghana, and the kids are trafficked from Mali and Burkina Faso, is that their families are starving. They're living in the worst poverty you can imagine. And so to get a kid off the payroll so you don't have to feed one kid and send them off to work, that's like a very poor solution to avoiding starvation. And it is, everyone who's worked in this field agrees, it sounds so simple, but the solution to this problem is to pay the farmers more. And that's its whole can of worms as to why that doesn't happen.
But I would point out, there is an upstream thing, an upstream contributor to what's going on in Cote d'Ivoire more particularly, which is that imagine the parents who are living in Mali and Burkina Faso who think it's a good idea to traffic one of their children into another country, right? And they're being paid for it. I mean, they hand their children over to a coyote, and there's cash in hand, right? So how bad does it have to be where selling a child into slavery is seen as any sort of option, right? It's not just solving endemic poverty in cocoa farms in Cote d'Ivoire and Ghana, but there's a regional discussion. You need to address endemic poverty in Mali and Burkina Faso as well, so that the parents of these children can afford to take care of them, all right, and don't see trafficking as a viable alternative. That's a lesson that I think I learned from watching The Dark Side of Chocolate. That this is going back. I mean, we've known about this for at least that long.
Oh, absolutely. Just a short and simple response is that if farmers if the owner of a plantation could pay a fair wage to a person they want to work on that farm, then instead of selling a kid off or allowing a kid to be trafficked, the father or an adult in the family can go get that job and be able to support the family. But that's miles away from where we are right now in terms of the poverty.
Okay. And as I was discussing with Terry just before we came on, I mean, a year ago, the price of cocoa was above $10,000 a metric ton, but still the cocoa bot in Ghana and the authorities in Cote d'Ivoire hadn't lifted the farm gate price. to reflect the huge increase in price on the markets. And now the market price is cratering. And so we'll find that, the COCOBOD and the authorities in Cote d'Ivoire are going to be forced to lower the farm gate price, which is going to put even more pressure, right, on farmers. And so we find that no change. The industry has learned nothing, right, basically from the price spike that has been everybody has endured over the last little while. I just want to take a quick break and say to everybody who's watching, this is Terry Collingsworth, the Executive Director of International Rights Advocates, and we're talking about the legal cases, the continuing cases of the fight to hold Big Chocolate accountable for its transgressions with respect to illegal labor in their cocoa supply chains in around the world, but specifically, or more specifically, in West Africa and Cote d'Ivoire and Ghana. We've done a little historical preview. We started back with the Hark and Engel protocol, even went a little bit before then, and we've moved through two major legal cases, one related around the Alien Tort Statute, another one around the Trafficking Victims Protection Reauthorization Act, and boy, that was a mouthful. If you have a question for Terry, go into the comments. I will get it asked, and we'll ask Terry to answer it for you. And then finally, what happened recently, Terry, to cause me to send an email to you and say, we have to talk about this. So what's the new thing that's going on?
Well, I'm so happy to say that this happened really fortuitously, that I was introduced to a lawyer named Kim Richmond, who has a firm in New York called Richmond Law and Policy. And he happens to be the premier consumer fraud lawyer in the United States. And he has been bringing cases all over the country based on consumer fraud claims. We were introduced and we compared notes, and we agreed that there was a fertile avenue here to use these consumer fraud statutes to go after big cocoa, because of, as I mentioned earlier, that most of these companies are making outlandish claims on their websites and even on their packaging that they're child labor free. They pay great wages to the farmers. They don't do this, they do that. All of these are their claims they're making to the public. Well, Washington, D.C. in particular, has a very good consumer fraud law that holds you accountable if you make false claims to consumers to induce those consumers to purchase your product. DC's law allows a nonprofit organization like mine, International Rights Advocates, to be the plaintiff and essentially act as the private attorney general for the population of DC. So I don't have to show I was injured. I don't have to show that I bought a candy bar and was angry because I found out it was made with child labor. I can and have just brought claims saying this company A has misrepresented what it's doing in Cote d'Ivoire. So the partnership became, Kim Richmond and his firm are experts on this consumer fraud law, which I knew about in passing. And I, with my contacts, I'm able to show that what these companies are claiming is not true, that we have the research to show that if company A says we don't use child labor, and well, here's a photo of a kid that's working on a plantation you're sourcing from. So we filed our first case together against Mars, Cargill, and Mondelez about a year ago. And all three of the companies we file in DC Superior Court, which is quicker. The judges there are really, really good judges, and they care. I think they care about their statute. This is DC's law. But the companies, they all removed us to federal court because there's a procedure where if you are diverse from, if you are from out of state and you get sued in a
diversity jurisdiction,
yes, that you can remove. Yeah. But there is a process to put you back if you don't meet the requirements of diversity jurisdiction. So in all three cases, we were removed to federal court. We were sent back to state court after we moved to remand. And then the companies all made a motion to dismiss. And we opposed that motion. And then the court finally ruled. I'm just grabbing the decision here. The case is called Kassim, Kassim, which is the name of one of the child plaintiffs, versus Cargill. but it's against all three of the companies, Cargill, Mars, and Mondelez. And the decision is just excellent. It goes through the history of the Consumer Act and prior decisions, and finds that the allegations made, if taken as true, allow us to bring this claim for consumer fraud. And the court also found that it had personal jurisdiction over all three companies. All three companies basically said, you can't even sue us here. Our headquarters is over here. But the court agreed with us that, look, you're selling your product in the District of Columbia to residents of the District of Columbia, and you are misrepresenting, at least the allegations are misrepresentations, and so the case can go forward. So there's plenty of cases like this, but this one in particular is the first time that we've really scratched the surface of getting a case moving along quickly. The fact that we've won this motion will allow us to get discovery, so that we can start getting the company's documents about their own knowledge of what's going on their plantation. So with this precedent, I think I mentioned we've already sued Nestle under the same law, and we're teeing up several other companies. One by one, we're going to hold these companies accountable for the things they're saying. And I hope that leads to us also being able to hold them accountable on behalf of the people that are being hurt by their actions in their supply chains.
So the children who are being forced to engage in the worst forms of child labor, for example.
Exactly.
And
so I have to be clear. The remedy under this law, the reason, the shark lawyers, the big personal injury lawyers and all of that, they don't use this statute because you don't get damages. What you get is injunctive relief. You get a court to declare that these statements are false, you have to fix them. And then the statute allows us to get attorney's fees and costs. So for us as a nonprofit, that is a perfectly viable equation, that we get to hold the companies publicly accountable for what they're saying. And if those statements are false, they're going to be enjoined from being able to keep saying that without making those statements true. And so I do think this is a very, very great development.
So would they be enjoined from making those statements within the District of Columbia? Because this is a state court, but they could theoretically make those claims outside the District of Columbia without any, theoretically?
Yeah. If once we get a judgment in the District of Columbia, virtually every state has a consumer protection law. So I don't think that you could really get away with having a double marketing strategy where you're misrepresenting in some states but not in the others. But if they wanted to try that, I mean, the big states like New York, California, Massachusetts, they all have pretty good consumer statutes as well. So I think they'd get caught pretty quick.
It would be easy. It would make it easier to engage in the same legal theory and try to hold them accountable. Right.
That's right.
But let's ask a question. So there were three plaintiffs, so Cargill, Mars, and Mondelez, and within the decision that just got handed down, Mondelez was treated a little bit differently. Right? Can you explain what happened? Why is the holding against Mondelez a little narrower than it is with respect to Cargill and Mars?
Just that the court acknowledged that Mondelez sells a lot of other products that the statements applied to as well, and limited it to their chocolate products that are sold within the District of Columbia, which would be Cadbury, and I think they make Oreos, a couple of other products like that. I'm sorry, I don't have those at my fingertip.
It's just important for people to know, for example, that Mondelez owns the Cadbury brand.
Yes.
Right? And Cadbury in the United States is manufactured under license by the Hershey Company. Right. And
yes.
And that's different from what Mars is selling in the United States. And Cargill is a business to business company. They don't have retail products, which are sold under the Cargill brand name. So there are differences in terms of the company's business structure that the decision that was handed down, right, needs to reflect.
Yes. Yes, but one minor correction is that Cargill, in fact, does have some consumer-facing products that are sold on their website and that you can buy at Walmart. So that was important for the court to hold them, to find personal jurisdiction over them, that they, in fact, are selling products in the District of Columbia.
Well, I have to admit that I rarely shop at Walmart, and I have, and one of the things that I've learned is this: just people, it's almost impossible to live a Cargill-free life. Right? It's their products are in so many things, it becomes almost impossible to disentangle, right? Them from your food purchases. So, and just so people know, for example, Mondelez owns the Hue brand, HU. And so would it be that if Mondelez owns Hue, that a finding against Mondelez would mean that Hue and other sub-brands that are owned by Mondelez would also be responsible for modifying the claims that they're making? Is that the way that
certainly
works?
would take that position. Yep, that if it's under their control, that I think it could be covered by any ruling of the court.
Gotcha. All right. So if anybody has any more questions, please put them in. Thank you, everybody, for, Andy and Gordy for putting the questions in. Happy to answer more. And the conversation can continue well after this. There's a comment section on LinkedIn. There's a comment section on Facebook. There's a comment section on the live chat in YouTube, which will not be live, but there'll be chat on YouTube afterwards, as well as on the post on the Chocolate Life. If you're a Chocolate Life member, you can ask the questions there. So, Terry, one of the things that occurred to me is afterwards is this notion that, and I put it in the post on the PodSafe Chocolate for today, is the potential for, I'm going to paraphrase this. I'm not going to ask you to read it off the screen, right? But if you're a specialty chocolate maker or you're a craft chocolate maker, and in your packaging and in your branding and on your website, you talk about how transparent you are and how traceable you are and all of these other things that you're doing, right? If, international rights advocates is not only successful, right, in getting a judgment, but then that judgment survives appeal, which is, if it's in state court, are they going to be able to remove it to federal court and go to the Supreme Court now that it's been remanded back down to state court?
No, they're going to have to stay in state court. So that's a great thing.
All right. So, and and with the caveat that you sell your products into the District of Columbia, right? But what it does mean for everybody, not just big chocolate, but specialty and craft chocolate makers, that you are legally going to be held to the same standards. Is that correct? Is that my understanding of the way things would go eventually?
Absolutely. That, the big targets that we went after initially are because we've been chasing them for years and years and years, and we know a lot about them. But yeah, I think everybody should take heart that when you make claims about your product, you are susceptible to this kind of suit, no matter how small you are. It's a question of whether you're selling it within the District of Columbia for our law, but in other states, the same thing applies. So, yeah, a lot of the craft companies are doing the right thing. I'm very proud to know several of them very well, but some of them aren't. And I think it's pretty easy to say we're small, therefore we're good, and that's not necessarily true. I've got to say the name Toni Chocoloni. When they started out, that was their whole shtick. We're small. We're owned by a couple of guys. We're going to do it right. We're not going to use child labor. Well, they do, and they're big now. But I think that they've been getting a free pass for a long time, and I know for a fact that they are doing things almost identical to the big companies. They just have much better marketing around it. So that's not going to save you if you are making false statements about how your chocolate is produced and how your farmers are being paid and all of that. You're going to be susceptible to this kind of claim.
So just a quick caveat again for small makers that while we might say, yay, this is a big win against big chocolate, right? That while the Alien Tort Statute is no longer a way to go and hold these companies accountable under the Trafficking Victims Protection Reauthorization Act, the TVPRA, right? The suit is going to be refiled, right? There's going to be a place to go do that. But under consumer protection laws, right? Even if we can't force the big companies to, number one, disgorge profits, for example, as a way of providing compensation, and the law cannot force them to change their practices in terms of buying cocoa. It just will force them to change the way they talk about how they source their cocoa. Right?
Yes.
So all those things are great, but if you're a small company, what it does is, you're not likely to be sued by anybody if you're buying 5 tons of cocoa a year. There's no economic value to anybody in doing that. But what it does say is that you need to start thinking now, because if Terry is successful is what he's doing, and it survives appeal, and that appeal will be shorter than, hey, taking it up to the Supreme Court, right? The time involved in it, right? All of a sudden, Big Chocolate is going to be not going to be making these claims anymore, right? And if you're making these claims, you need to do a better job of verifying your supply chain, right? So that the claims that you're making are ones that could be supported in evidence.
Exactly.
Is that
So
correct?
yes, and absolutely. If you're a company making, let's stick with chocolate. If you're making claims about how your chocolate is produced, sourced, how you pay your farmers, how you treat your farmers, and all of that, if those aren't true, then you are susceptible to this kind of claim. So you have a choice, and we stress this to Big Chocolate as well. What we'd like you to do is make your statements true. That's one way to defend in the future, is make your statement true by actually doing what you say you promise that you're doing. But if you're not going to do that, you can't say anymore something that is not true. So the advertising for Big Chocolate is going to probably have to revert to, this is really sweet, eat it.
Right. So yeah, so one way to think of this is a way to prevent greenwashing, right?
Yes.
As much as anything else. But it does represent an opportunity for small chocolate makers to get together, right? To be able to agree on a set of standards around reporting. But this is an interesting question. So does it mean that you can't rely on FLO fair trade certification? Because FLO fair trade certification would need to prove that they're actually doing what they say they're doing, for example.
Yeah, absolutely. That's not going to be a safe haven at all, because first of all, if you are a big cocoa chocolate company and you're using fair trade, you probably already know that fair trade is not accurately making claims on your behalf, that it is itself committing consumer fraud regularly, and we are absolutely looking into them. But it's not going to be a safe haven for.
So you said you've got Nestle lined up as a future potential defendant. Are you literally thinking about going over some of the fair trade organizations that are headquartered in the United States?
Absolutely. Well, first, we did already sue Nestle. That is so. Okay. Nestle removed to federal court, and now we're filing. Then they got remanded just now, so we're working on a briefing schedule. So Nestle is already in the dock. But yes, we are looking at fair trade and Rainforest Alliance in particular, because of my personal experience with them goes back years and years of investigating what they're actually doing on the ground in Cote d'Ivoire and Ghana. And the answer is almost nothing. And yet these companies put that label on their chocolate bars and people believe it. It's probably even worse than what the companies are doing, because fair trade is really violating their trust. They're saying our label means this is a good company when it doesn't mean anything. So that is like a double fraud in my mind.
So one other question, and I think it's a great timing for this. So this is again from Andy, who says, big cocoa aside, does shopping at bean to bar chocolate producers actually keep us free of big cocoa's influence?
Oh, you're probably better positioned to answer that than me, Clay.
It's an interesting segue, and it's right there. And the answer to that question is maybe. Right? And one of the reasons why I talk about it is that many small companies, small chocolate makers, rely on cocoa processors, right? And others for their logistics. So, for example, you might be buying from, I don't know if this is currently the case, but it was several years ago, is that Uncommon used the services of a company called Ecom, right, for transportation logistics, right? And so Ecom is not a good actor, I would think it's fair to say, Terry, in terms of
Very
this.
fair, yes.
And so, I mean, again, thankfully I'm not in the UK and we can't be held to their libel laws. American libel laws are very, very different. But this is an opinion, right, that we're stating here, right? And we're not using any inside knowledge that, we have that other people don't. So you need to ask the question, and this is a rabbit hole question. How far down this rabbit hole do you want to go? Does the fact that Uncommon has in the past and maybe currently using Ecom for transportation logistics, right? Does that make them, is there any sort of taint associated with that? This is one of the arguments that I make against Tony's Chocolonely, which uses Barry Callebaut for all of their chocolate manufacturing. It may be that Tony's cocoa bean supply chain is better than, not perfect, better than Barry Callebaut's cocoa bean supply chain. But the fact that all of those beans go to the factory in Visa, Belgium, and all the chocolate is transformed there before it gets sent to Amsterdam for molding into bars, or the Netherlands for molding into bars, right? Does that connection mean that Tony's Chocolonely product is tainted by Barry Callebaut's work? I claim the answer is yes, they are. You cannot divorce the ethics of sourcing for the ethics of manufacturing and buying. So it's really, really important that we understand that. And so there are other ones. For example, very few, I'll take it back. If you're a small chocolate maker, very few of them make their own cocoa butter. And so if you're buying cocoa butter, but you're buying cocoa butter from Blommer, which is owned by Fuji Oil, or you're buying cocoa butter from Ecom, or you're buying cocoa butter from any one of a number of companies, then no, right? You are not free from big cocoa's influence, right? You need to make sure that you're buying your cocoa from a small cocoa butter manufacturer. I mean, a friend of the Chocolate Life is this Ecuadorian company called Cocoa Supply. I mean, I've been to their factory. I've seen their cocoa butter presses. I know how it is that they're doing all of those things. And I've been to some of the farms that they purchase from. And so what it means is that you as a consumer are going to need to know more about that question about who the makers that you're buying from. They're going to need to be more open about who they're buying their cocoa butter from and other ingredients, because, oh my gosh, if they're using nuts for inclusions, right? And so there is optimism. I think we have reasons to be optimistic about where this consumer protection lawsuit is going and the ultimate outcome of it. But what it does is it also makes specialty chocolate, craft chocolate, bean to bar chocolate, whatever you want to call it, all of a sudden we need to make sure that we are walking the walk, right? And not just talking the talk. We've made all these claims about being better. We're going to need to be able to document and verify, not certify, but document and verify that what we're claiming is actually true. And in that respect, Terry, so I like visibility. There's a visibility to what's going on because transparency is so overused. It's like authentic. I don't like authentic and transparent and all that kind of stuff. It's just, they have been expropriated and misappropriated in so many ways. But let's talk about another success, right, that you have had at International Rights Advocate, and that's around Rugmark.
Yes.
Is that what's going on? So does what you did in Rugmark provide sort of a framework for being able to do something like that in cocoa and chocolate? Yes. So tell people about Rugmark, what it's all about, and what you ended up doing, and how this program works.
Well, Rugmark is now called Good Weave. It got bigger, and it's now Good Weave. So you can go to www.goodweave.org.
And I'll put a link in today's post. I'll put a link in today's post to it.
Great. It's a great organization. But back when it was Rugmark, the idea came from Nobel Peace Prize winner Kailash Satyarthi, who's Indian, and ran an organization, Free the Slaves, in India. And hand knotted carpets in South Asia were just absolutely one of the worst examples of abuse of children, child slavery. Literally, kids are chained to looms and they're making these hand knotted carpets. And so Kailash's idea was that once the word got out there that child labor is horrible in the carpet industry, some people wouldn't buy a carpet at all. They'd say, I don't want anything to do with this horrible kind of slavery. So his idea was to figure out a way to feature carpets that are not made with child labor. So he created this system where you, as a carpet manufacturer, you could join Rugmark, now Goodweave. You'd have to disclose where all of your looms are, and you'd have to allow for surprise inspections by the organization Rugmark, and you had to agree to certain conditions of what would happen if we found children on your looms, and you had to pay for it. You had to pay a small fee, like 1% of your total export value went back to Rugmark to fund this monitoring system. And it not only it succeeded, it thrived, because the good carpet makers said, yeah, I want to disassociate from the industry generally. I want to show that we're really good. And now you can go to really any high-end hand-knotted carpet store and you'll see Goodweave labels there, and that's your assurance that the carpets are child labor-free. It also funds this fee that the carpet manufacturers pay. It funds rehabilitation programs, and that to me was the most joyous part of the work. Thousands of kids were rescued from looms in India, Pakistan, and Nepal, and were put into our rehabilitation programs and thrived. There's a member of parliament now in Nepal named Ram Prasad, who started out as a carpet child and went through this whole system, and I'm so proud of Ram. But it's a great system. So I have repeatedly offered to the cocoa industry that we could do something very similar, that it would probably be even easier, because in India, these looms were spread out all over creation. Any little shed could have had a loom, and we had to figure out a way to get to them. But cocoa production is open, it's concentrated. We could easily do a monitoring program within the industry. And so far, we've had no takers. I feel confident that we could do this so easily.
So, Terry, there's something I've been working on. People don't know this about this. I've started to engage with a small group of people to put it together. And what I'm hoping you'll do is you'll hold the line after we end the call. But I think the place to do this, that the current lawsuit, the consumer protection lawsuit, the place to start this is with small chocolate, not big chocolate, right? So, one of the goals of what it is that I want to do is to take specialty chocolate from roughly 5% of the market to 25% of the market, by in the next decade. And then how do you go about doing that? And one of the ways to do that is to demonstrate value, right? So we don't know how many small chocolate makers are in the world. We don't know how much cocoa they buy. They don't know where they cocoa. We don't know the economic value of the product that they're selling, right? And none of them has the resources to be able to, join the World Cocoa Foundation. And if they did, what would that mean for them, right? And so perhaps there's a way to fold the idea of the Goodweave version for cocoa and chocolate into that. And if anybody thinks that's a good idea, let me know. And you have resources that would like to make it happen. But I think, Terry, this is a way that you and I can work together, and I can weave, pun intended, weave this into the discussions I'm having with a whole bunch of other people. Because the challenge that all of these small chocolate makers will give, same ones big chocolate makers would give, and you solve the problem in rugs, is that nobody wants to give up their sources of supply. Nobody wants to be radically transparent about how much cocoa they're buying, how much they're paying for it, and from whom they are buying it, right? And because they think of that as proprietary information. And how do you de-identify it where you can get the information without exposing the details to the public? There's all sorts of stuff going on there, which needs to happen, and you solved it. And so I'm glad that we're able to come all the way around and get to there. And that's the hour. Actually, we're a couple of minutes long. Terry, is there something you'd like to say to help close out today's program?
Well, thank you. I think all of us, if you're on this program, you're interested in chocolate, a lot of the problems that we're discussing would certainly be helped if consumers were more active. And I think that that is one of the keys that we're not really seeing enough of. So if you're a consumer of chocolate and you want one of the big companies, pick anyone you want, Nestle, if you want them to improve their practices, tell them you're not going to buy their products until they do. There's so many ways to contact them. We have a place on our website where you can just click on it and write them a letter. But consumer power has not been properly harnessed in this space. And if we can come up with a good idea that Clay was just discussing to reward the companies that are doing it the right way, that we can verify are doing it the right way, then that's another thing that consumers can do. So punish the bad guys, reward the good guys, and let's see if this capitalist system can actually do some good.
Right. And before we close out, Juan Gonzalez, who's with Mabco, which I believe is the Mexican Arabica bean company, he's up in Canada, has said, we stand strong against child labor. That is core of my company values. Since if I start my business, I always visit farms to be sure I mention to my suppliers the big problem of child labor, transparent with information, never buying or doing business with any African cocoa beans producer where you find this problem. This is great. Juan, I've known you for quite some time. We've had conversations. I don't know that I've ever met you at the farm level, but it's really important. But here's a point that I want to make, is that we don't want to avoid the problem. By saying we're not going to do business in West Africa, you're not contributing to the solution. You're just avoiding being a solution. And so the challenge becomes, how do we take companies like yours, not necessarily yours, Juan, but companies like yours, and engage them in doing business that is actually ethical, open, transparent in West Africa? How do you go about doing that? How do you go encourage the companies that are doing that so that they can be part of this larger movement? It would be great if we could say, here is a supplier, let's say, I'm just picking one, Three Mountains Cocoa in Ghana, and we visited them. I know Leslie, I've never been to the farm, but we could say, this is a trusted supplier of beans in this part of the world. I mean, I think we need to not avoid West Africa, but embrace West Africa in order to be able to solve the problem. I don't know, Terry, if you feel the same way.
Absolutely. In fact, I'd go even stronger and say, let's not punish the farmers in West Africa because they're able to be abused right now. Let's help them.
Yeah. Right. And then finally, quickly, Andy LeBlanc says, thanks. It's been eye-opening and gives me hope. Absolutely. And I think that's a great segue. Again, Terry, hold on, but I do want to remind everybody that this has been Pod Save Chocolate. It's sponsored by the members of the Chocolate Life. If you're not a member, you can go over to the website, click on join, become a member. Always a free membership tier. Oh, go over to International Rights Advocates. There's a link on today's episode. If you have the resources to support them, they are, in fact, a nonprofit organization, and they depend on the support of people like you and people like me to keep them in business and to do this work. That would be great. I want to say thank you to everybody who's been here, the questions and all that kind of stuff. And remember, if you're working with chocolate and you're not having fun, even when you're dealing with really, really important, critical issues that affect the lives and livelihoods of people around the world, if you're working with chocolate and you're not having fun, you're doing it wrong. Until the next time, everyone, thank you very much. And thank you, Terry.
Thank you, Clay. I appreciate it.
Ciao, everyone.